Hypocrisy.
Okay. Well, that was fun. Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. How's it going? As I said when you couldn't hear it, let's just address it and move on. I'm not going to dwell on it. Yes, I'm really late. Yes, I'm sorry about it. Some shit came up last minute and went way over after I had scheduled the show, and that's it. I'm not going to sit and fuck around whining about it. We're just going to go. I'm getting my windows organized. My stream was muted because some people may have seen I had some guests over today and they did their show from my office. So now I'm rearranging and reorganizing all of that shit real quick. My camera angle is different and stuff. Oh my gosh. It's like someone like snuck into my house and rearranged my furniture or something just a little bit. It's weird. But we've got some good subjects today. Oh, also apologies for the typo. Well, the habit typing on locals and Twitter. It was supposed to say 11:30 like the streams. Of course, I ended up being 30 minutes late. So, you know, there's that. But it was supposed to be there. What a mess. What a mess. Let's do this. Hold on. One more thing. One more thing. We're gonna grow a little bit. What? We're gonna grow a little bit more. There, that's better. That's closer. I think that's closer to where we were beforehand. Anyway, it doesn't really matter. Am I in frame? Yes. There we go. Let's get rid of that. All right, tonight we have a couple topics that we are going to hit. Donald Trump has been removed from the Colorado ballot. The Colorado Supreme Court has issued their ruling and have decided that under the 14th Amendment, he is not qualified to sit as president and therefore cannot sit on a primary ballot. There you go. He does not get to run as president in Colorado. This is not the final detail. Obviously, this is going to go up to the Supreme Court. Donald Trump is still going to be making interesting law and forcing the Supreme Court to come up with the bounds of the 14th Amendment. The order is currently stayed until January 4th. January 5th is when the primary ballot has to be finalized. Trump will presumably get an emergency ruling from the Supreme Court one way or another prior to that. We're going to read the story. We'll see if the decision's available. We'll talk about it. But I think the decision is out there. And we'll go through it. We'll grab this stuff. This is a wild turn of events. This is the first court to find that the 14th Amendment even applies to a president or applies to a primary ballot in any way. There is no federal guidance on the 14th Amendment applying to a president of the United States. This has never been done, obviously. And that is a whole different thing, man. It is It's something. It's something. Now, does this have to do? Does this stop Trump from winning the presidency? No, it's just Colorado, right? It's just their electoral votes. Now, obviously, you want to have all of the possible electoral votes there are. We definitely want that for every serious presidential candidate. All of that is there, and in theory, he could still win without Colorado. But that being said, this could be permission for other courts to follow suit, for other states to follow suit. Courts that have ruled this way on the primary ballot or have ruled the opposite way on the primary ballot may rule along with this on the main ballot. There's a lot to this. It's we just got to get into it in a minute. Because there's just so much to talk about, and I don't want to do it all in the intro. So then I guess we'll see how the time is going on this. We should be fine. We'll do updates on my own lawsuit. There's at least one one filing that's new to me that I've not covered. Someone was asking me the other day, why aren't you covering your own lawsuit? And I was like, well, because I don't really think about it most of the time. There's nothing for me to do. Just wait. Just sit around and wait. And there's some, what's going on back here? There's some filings that have occurred, or at least one filing that's occurred, and then maybe two. We'll grab those and see what is up with the ongoing Rekieta Law versus Montegraph lawsuit, which is quintessentially the stupidest lawsuit in town. Yeah. Yeah. Yeah, I don't know, man. The thing's going to go on forever. It's going to be great. It's just it's achieving all of Montegraph's goals of costing me a fortune over a frivolous lawsuit. Thanks. But that being said, we also have a death penalty case that I was hoping to talk about yesterday. Didn't quite get to it. Didn't quite have the energy to really get into it. We may get there today as well. Hopefully we'll get there today. But it all depends on the time of everything. Now, I'm starting this show way late. We've got to get moving. I'm not going to belabor this any further. Let's get the Trump Colorado ruling. And then let's take a look at this. This is pretty recent news here. I'm flabbergasted that this would happen. It's so not within the purview of a state court to find insurrection, a federal insurrection, and then find application of the 14th Amendment in a way that the 14th Amendment doesn't actually work. That it's all very strange in that respect. So let me see if I can find the actual document of this. Where's it? Oh my gosh. Give me the fucking ruling. And I was, yeah, like I said, a little surprised. Just someone give me the damn ruling. Is this it? Four 3 ruling. Here we go. Now, this was a split court. And, oh, gosh. All these damn pop-ups. Oh, my gosh. Almost there. Sometimes getting these documents is an absolute fucking nightmare. All right. All right. All right, here we go. So here is the ruling. How many pages? This is 213 pages. How many fucking? We're going to read some summaries. We're not going to read 213 pages of this bullshit. This is a per curiam opinion. More than 3 months ago, a group of Colorado electors eligible to vote in the Republican presidential primary, both registered Republican and unaffiliated voters, the electors, filed a lengthy petition in the district court for the city and county of Denver. Denver District Court or the District Court asking the court to rule that former President Donald J. Trump, President Trump, may not appear on a Colorado Republican presidential primary ballot. Now, these had to be Republicans because this is a primary ballot, not the main ballot. Invoking provisions of Colorado's Uniform Election Code of 1992, the electors requested that the district court prohibit Jenna Griswold, in her official capacity as Colorado Secretary of State, from placing President Trump's name on the presidential primary ballot. They claim that Section 3 of the 14th Amendment to the U.S. Constitution disqualified President Trump from seeking the presidency. More specifically, they asserted that he was ineligible under Section 3 because he engaged in insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. We've got a footnote here. Consistent with past practice in election-related cases with accelerated timelines, we issued this opinion per curiam, which means that you don't really get to see like who wrote it and everything. You just get to see the vote split, but that's about it. After permitting President Trump and the Colorado Republican State Central Committee to intervene in the action below, the district court conducted a 5-day trial. The court found by clear and convincing evidence, which is actually a heightened standard in civil practice. Civil practice, you have a preponderance of the evidence, which is 51% or higher. Clear and convincing is a higher one than that. It's somewhere around 60 to 75%. It's not really perfectly laid out. It's not really perfectly laid out, so you don't know exactly where it is, but clear and convincing evidence that President Trump engaged in insurrection as those terms are used in Section 3. Now, again, first question I have is, why does the Colorado Supreme Court have anything to do with determining someone engaged in insurrection, which is a federal offense, against a president of the United States, which kind of makes it curious. Like, there's a conceptual. Hold on one second. There's a conceptual issue with a president of the United States, a sitting president, even though he's quote unquote on the way out insurrecting against himself. You have to ask how that can even happen. How can a president who is the representative of the government insurrect against their own government? Now, some would say, well, he's trying to stop the peaceful transition of power, blah, 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 blah. But he didn't, though. Like, he didn't actually do that in any capacity. Even if you get to the point where you say he incited a mob on January 6th, which there's no way you get a criminal charge of incitement on Trump in this stuff to stick. It's just, I mean, I guess you could say there's some way. There's always some corrupt way you could do it. But he doesn't seem to fit any of the criteria for it. He has First Amendment protections. He has presidential protections. He has all sorts of stuff going into it. And it's conceptually, you just wonder, how does the government insurrect itself? So, yeah. Let's see. But the district court concluded Section 3 does not apply to the president. Oh, I think we actually covered this case. Therefore, the court denied the petition to keep the President Trump off the presidential primary ballot at Part 4 conclusion. Or wait, that's just a citation. Yes, we did talk about this. The judge found insurrection, but then said doesn't keep it. It doesn't apply to the president, which is the actual correct ruling on this. That is the correct second part. Finding insurrection is not the correct answer. But finding that Trump or that the article. Sorry, I just slow down. Article 3 of the 14th Amendment does not apply to the president is a correct ruling. The electors and President Trump sought this court's review of various rulings by the district court. We affirm in part, reverse in part. We hold as follows. The election code allows the electors to challenge President Trump's status as a qualified candidate based on Section 3. Indeed, the election code provides the electors their only viable means of litigating whether President Trump is disqualified from holding office under Section 3. The problem is Section 3 doesn't have a means of litigating anything in regards to this. That's the crazy part. Section 3 does not provide a means to challenge a president, to challenge anybody. There isn't a mechanism for it. Section 3 of the 14th Amendment actually just has a way for someone who is disqualified to become requalified. So we have a reading issue here. But here we go. Congress does not need to pass implementing legislation for Section 3's disqualification provision to attach, and Section 3 is, in that sense, self-executing. You don't get a civil court finding of participation in insurrection that satisfies Section 3. This is an insane proposition here. Judicial review of President Trump's eligibility for office under Section 3 is not precluded by the political question doctrine, which is stunning in and of itself. Section 3 encompasses the office of the presidency and someone who has taken an oath as president. On this point, the district court committed reversible error. This is not actually accurate. There is a lot to counter this notion. The district court did not abuse its discretion in admitting portions of Congress's January 6th report into evidence at trial. District court did not err in concluding that the events of the U.S. Capitol on January 6th constituted an insurrection. And the district court did not err in concluding that President Trump engaged in that insurrection through his personal actions. President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6, 2021 was not protected by the First Amendment. This is, again, an insane proposition when you factor in Brandenburg v. Ohio and the fact that Donald Trump and his speech happened miles away from the incited crowd who were not present. The Donald Trump crowd that would walk down to the Capitol building from the White House got there after the incited insurrection had already started. So we just have these questions about this. We've talked about this during Trump's impeachment. There are so many problems with getting to all of this. And here's a big one. Federalism. Federalism is a tiered system of governance where you have municipalities, states, and eventually the federal government itself. The idea that a state court can find insurrection sufficient to remove a president from the ballot is a problem. All right? Like, hear me out. Think about how this works. Colorado makes a finding of insurrection and then removes Trump from the ballot. Minnesota didn't. Well, shit. Now we have a state making a finding that has federal implications across everyone, because now Donald Trump does not qualify for that state's electors. But how can you have disparate results on the disqualification? How can you have two different states come to different conclusions? If he's disqualified under Section 3 of the 14th Amendment, how can it not be universal? Now, Minnesota would probably find him guilty of insurrection. They didn't actually consider the question. But you have to ask if Texas would. Would Texas put Donald Trump there? And if no, why? Oh, you say it's politics? Well, they said it wasn't a political question. This is just not in the purview of a state court. I would say it's not in the purview of any federal court. And in fact, it's not really in the purview of anyone, maybe the Supreme Court. But there's no finding of insurrection other than a civil case in Colorado about events that happened in Washington, D.C., where a state Supreme Court is holding the president of the United States at the time, and therefore the executive branch, at a lower position. How is the executive even under the jurisdiction of the state court of Colorado on this matter? This is crazy. Crazy town. But let's do this. We always have to do this, I think. It's always good to just actually remember what the 14th Amendment says. So we're gonna do that real quick. It's section 3, because this is what they're doing, what they're using as justification, and why this matters. All right. I want you to find in section 3's language where a state court can make a finding of insurrection that no one else has made, and then apply this to a president. Let's see. No person shall be a senator or representative in Congress or elector of president, vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. How does the disability apply? How does the disability apply before it can be removed? This is a quintessential question. How do we get there? No one knows. There isn't a mechanism. There's nothing that says how to do this. One would presume that there would be either an open and obvious, notorious, massive insurrection that occurred right around the passage of this amendment. I don't know, maybe the Civil War. Or one would further suppose that maybe there would be an actual criminal insurrection charge, or some sort of aid to the insurrection, like incitement to insurrection or something like that. You'd think that would occur, that there would be a criminal conviction that would then say this person is guilty. Let's not even get into the fact that they list senator or representative, elector of president, vice president, or hold any office, blah, 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 blah. But the president himself and the vice president are not mentioned, despite the mentioning of these 4 very specific lesser offices. Those are mentioned specifically, but not the president, not the most important one. And there's probably a reason. One, because it's highly possible that the 14th Amendment Section 3 was literally only written to apply to the Civil War. It's quite possible that that's true. And if that's true, what do? It should never be used again. Now, it doesn't say one way or another if that is true, but it explains a lot, because the people who are specifically mentioned in this thing are all easily identifiable actors in the Civil War. They're all identifiable, obviously, openly, and notoriously in their roles. We know who took these oaths. We know who's with what state. We know who were the congressmen, the senators from those states. Even at the federal level, we know all of that. It was easy to figure out who they were. Same with military officers, etc. And then they were automatically found to be unable to hold those offices. And then if they decided to run, then the House and the Senate, Congress may, by 2/3, a vote of 2/3 of each house, remove such disability. Well, the disability attached automatically because everybody knew who they were. That was the whole point. The reason they didn't mention the president, I don't know, because Lincoln stayed with the Union. So it's not like they needed to mention the president of the United States. They didn't have to do that. Why would they? He didn't go anywhere. Now, there's another possibility, though, which is similarly practical, but in a completely different way. The president of the United States is often treated differently simply because of the public influence across the entire nation on the election of the president. Even originally, when the electors were just determined by actions of the houses of Congress of various states, you're still talking about the representative government of these states choosing the electors who would pick the president. Okay. When that, of course, metastasizes into what we have now, which is some bastardized version of a popular vote, not a pure popular vote, but some version of it. Well, now you have this different system where, as of the last election, you have approximately 160 million people of the voting age population casting their votes, and a little over half of them, one way or another, are going to get their way. Well, that's a lot of political capital. And so it may be that the founders, the framers, however you want to call them, whatever it is, they had determined that the president did hold this special place because of their public involvement, because of their public power, because they don't want to deprive the country of who the country wants to run it. If Jefferson Davis, after the Civil War, was able to win election as president, would this have disqualified him? What about Robert E. Lee? We don't know. It didn't happen. But there's questions about this, right? Like, what if the country wanted those people as president? Who were the drafters of the 14th Amendment to say they couldn't be? Now, of course, you could just simply say, well, they could just have Congress vote. But why didn't they write it in? Can't be president. Why not? It's a good question, I think. I don't have an answer. There's a curious thing, though, about this amendment. Why didn't they just write it down? Why didn't they just write it down? They could have. They have the pen. All they have to do is just there. And president, though. But they didn't. It's a very curious problem with this entire thing. And that cannot go unspoken. But even ignore, so that's the 14th Amendment. That's what it says. Even ignoring all of that, we've got something else going on here. We have a state court applying this to a president. Again, I was getting to this earlier, but we have a state court taking power over the entirety of the federal election system. That does not comport with general ideas of federalism and is inherently should be barred, at least from this court, as a political question. But it's really suitable only for the Supreme Court of the United States, especially when it comes to the president. Now, maybe you could argue that Colorado could keep their own representatives or senators off their ballots. Maybe you could argue that. I'm not entirely sure that that the application of the 14th is within the purview of a state court in that way. But if it is, then it makes sense that the president is not included, because this necessarily deals with localized elections, localized people. If a state court is able to do it on a state-by-state basis, it cannot include the president of the United States, because coming to disparate conclusions on the president doesn't make any fucking sense. And that's critical. That's critical. Tyrannidis says the Prez not being part of the 14th makes sense. President is the top negotiator. So say in war, the president works out a peace deal, but someone didn't like it. They could accuse the president of treason for aiding the enemy. Right. Yes, of course. We talked about this in terms of all of these Trump cases. This stuff has come up, things like the documents case and stuff. It's like, well, can a president actually illegally release a classified document? Because if he releases it, it's declassified, at least to the extent of his release. So Anyway, my goodness, I got fucking fires to put out, and I'm really annoyed by having them because it's like trying to do a show. All right, let's get back into this. Here we go. We're still in the kind of synopsis of this. Some of these parts is this: President Trump is disqualified from holding the office of president under Section 3 because he is disqualified. It would be a wrongful act under the election code for the secretary to list him as a candidate on the presidential primary ballot. But again, how can a state make this determination on their own? They can't. We do not reach these conclusions lightly. Yes, you do. We are mindful of the magnitude and weight of the questions now before us. We're likewise mindful of our solemn duty to apply the law without fear or favor, without being swayed by public reaction to the decisions of the law mandates we reach. This is one of the most laughable lines in this opinion right here, because this is entirely about what they just said it wasn't about. Gaslighting to a fucking T. Gaslighting to a fucking T. And I'm really fucking tired of gaslighting. So with that, we're going to move on from it. But this entire concept is them making a highly politicized and publicized decision over a president saying they're applying law that has no model for them to apply. And again, impacting the entire federal election system in the process. We are also cognizant that we travel in uncharted territory. This case presents several issues of first impression, but for our resolution of the electors' challenge under the election code, the secretary would be required to include President Trump's name on the 2024 presidential primary ballot. Yes, it would. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4th, the day before the secretary's deadline to certify the content of the presidential primary ballot. If review is sought in the Supreme Court before the stay expires on January 4th, then the stay shall remain in place, and the secretary will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. So this is stayed, as mentioned, but we have this ruling now. We have this ruling. They say they didn't do it for any particular reason except, throwing a wrench in the entire election process. We have conceptual problems with this. How can a state hold this over a president? Does this keep the president off of other ballots? I mean, they have found insurrection now. Do other courts get to rely on this? Do they have to rely on this? What happens here? This is completely uncharted territory. There is this idea that other states must honor the rulings of their sister states. And this one it's a nationwide ruling, right? He is guilty of the insurrection. The Colorado court heard all the facts from the Washington, D.C. incitement to insurrection question, and they determined in Colorado that he did it. So now they are removing him. Does every state have to remove him? And if not, why not? If another state comes to the conclusion that he did not engage in insurrection, what is Colorado supposed to do then? You see, we would have a means to solve this if it was a circuit split at the federal court. But this isn't a circuit split at the federal court. The Supreme Court should merely vacate this ruling immediately and say that no state has standing to hold the president off of a ballot without an actual conviction of insurrection at the federal level. Gandhi's nuts says what? Dude, okay, Gandhi's, you could do what you want to do, like donate however much you want. I tend to read the $20 and up super chats first as I'm going through the show, and then I get to the other ones as we progress. I will get to and answer your question, just not at this moment. But I'm not ignoring it. It's just how I've done my show for 4 years now, 4.5 years, something like that. But I will get to it. Sorry to not be clear on that. Fagan's Law says, keep up the good work, Roe, counselor. Thank you. This is, this really goes to, again, the heart of these questions of federalism, separation of powers, not just between the branches of government, but between the vertical divisions of government. Can a state do this? This brings up all kinds of fucking problems. And again, my mind is blown on how they get president out of it when president is not explicitly included in this. Oh, there is one more thing to contemplate. Let's do this. There's a very, very specific thing that is stated. We'll go here. Remember, one of the qualifying things back here in the 14th Amendment was who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States. All right. To support the Constitution of the United States is the required language here. What is the actual presidential oath? I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Now, let's see what it says about a senator's oath, right? Surely we can compare this and find some reasonable discrepancy. I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion. Oh, okay. So let's see. Oath of House of Representatives. If I could type this. Here we go. Oh, that's ugly. Shit. Well, the website for this is a disaster, but here's what it says. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance. It's basically the same as the Senate. Now, why is it that we have this specific language here that says previously taken an oath to support the Constitution of the United States? It's absent from the presidential oath. It's present in the oaths of the people they're talking about. Isn't that amazing? Isn't that weird? You have a lot of evidence that the president is specifically excluded from the 14th Amendment, Section 3. And yet, here this court not only decides as a state court that he is included with no prior authority to do so, no reliance on any Supreme Court guidance or other jurisprudence. They just say he must be, and then they apply it at the state level. It's amazing. This is so far out of pocket for what the Supreme Court of Colorado should be able to do here. But hey, that's where we are. I don't really want to go through. Well, let's go through just this background real quick for the case, and we get a little taste of what we're doing. But again, this is 200 pages, and we're not going through much more of it at all. But background: on November 8th, 2016, Trump was elected as the 45th president of the United States. He served in that role for 4 years, despite the fact that many people tried to overturn that election by claims of fraud, people like Hillary Clinton, etc. That lasted all 4 of those years. On November 7th, 2020, Joseph Robinette Biden Jr. was elected as the 46th president of the United States. President Trump refused to accept the results, but President Biden now occupies the office of the president. Wait, how did he refuse to accept the results? Critical fucking question. Because he didn't like them? Because he said there might be fraud? Because he did this? Did Donald Trump leave office? Yes. Did he participate in the constitutional inauguration of Joseph Robinette Biden Jr.? Yes. Did he in any way attempt to stop Joseph Biden Jr. from taking office on Inauguration Day? No. Not at all. So how did he refuse to accept the results? He could have, I guess, resisted attending. He could have tried some matter of petulantly avoiding it, but he didn't. On December 14th, Electoral College officially confirmed the results. 306 electoral votes for President Biden, 232 for Trump. Trump continued to challenge the outcome both in courts and in the media. So, January 6th, pursuant to the 12th Amendment, U.S. Constitution Amendment 12, and the Electoral Count Act, Congress convened a joint session to certify the Electoral College votes. Right. President Trump held a rally that morning at the Ellipse in Washington, D.C., at which he, along with several others, spoke to the attendees. It's critical that only he matters here, not the several others. In his speech, which began around noon, President Trump persisted in rejecting the election results, telling his supporters that we won in a landslide. We will never concede. We won't concede. We can't concede. He didn't have to concede, by the way. He didn't concede. He urged his supporters to confront this egregious assault on our democracy, walk down to the Capitol, and show strength, and that if they did not fight like hell, they would not have a country anymore. Kind of left out some stuff there about like peacefully making your voices heard. Just kind of left those quotes out, right, Court? Before his speech ended, portions of the crowd began moving toward the Capitol. Below, we discuss additional facts regarding the events of January 6th as relevant to the legal issues before us. Just before 4 a.m. the next morning, January 7th, Vice President Michael Pence certified the electoral votes, officially confirming President Biden as president-elect of the United States. President Trump now seeks the Colorado Republican Party's 2024 presidential nomination. So again, where did he actually stop this in any way, or attempt to, or intervene, or interfere with? He didn't. But remember, if you say fight, you're committing insurrection against the government. Fight, 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 fight. Just remember that. Just remember that. Every one of those people apparently insurrectionists. Skip the procedural history because it's boring. That's how it got there. And analysis. Here we go. We've got Jason of TGA says every Colorado judge, juror, prosecutor, lawyer just signed themselves up for intense anon rabbit hole digging, whether they were on the Trump case or not. Hope they have no Pelosi's in their closets. This is amazing. Oh yeah, the intro playing was intentional. That intro, if you guys don't know, was basically that section was taken from a compilation video that was presented at Trump's impeachment. One of the critical arguments at Trump's impeachment was that his use of fight like hell was indicative of him insurrecting the government. And so his lawyer just put together a compilation of a bunch of Democrats saying fight, 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 fight. And their fights were not as obviously metaphorical or idiomatic as Trump's, but hey, they did that. And it's it didn't matter though. None of this matters because it was never about the truth. It was always about politics. So analysis, we begin with an overview of Section 3. Oh, this should be good. We then address threshold questions regarding whether the election code provides a basis for review of the elector's claim, whether Section 3 requires implementing legislation before its disqualification provision attaches, and whether Section 3 poses a non-justiciable political question. After concluding that these threshold issues do not prevent us from reaching the merits, we consider whether Section 3 applies to a president. Concluding that it does, we address the admissibility of Congress's January 6th report before reviewing and ultimately upholding the district court's finding of fact and conclusions of law in support of its determination that President Trump engaged in insurrection. Lastly, we consider and reject President Trump's argument that his speech on January 6th was protected by the First Amendment. And they do it because here's a footnote. President Trump also listed a challenge to the traditional evidentiary standard of proof for issues arising under the election code as a potential question on appeal, claiming that when particularly important individual interests, such as a constitutional right, is at issue, the proper standard of proof requires more than a preponderance of the evidence. So they just went to clear and convincing. As noted above, the district court held that the electors proved their challenge by clear and convincing evidence. And because President Trump chose not to brief this issue, he has abandoned it. He has abandoned it. Perfect. Wonderful. Okay. All right. Cool. So he doesn't get the First Amendment issue because he did not brief it. So it's abandoned, apparently. Section 3 of the 14th Amendment and Principles of Constitutional Interpretation. Here, let me read these Gandhi's Nuts chats real quick. He says, how can judge remove a candidate who is 34 versus this? And then he said, sorry for the misunderstanding. Cheers. A candidate who, let me word this appropriately. A candidate who cannot serve as president on Inauguration Day, I believe it is, because they are not 35, cannot sit on the ballot. They cannot do it. It would be a disenfranchisement to voters who would place their vote in a candidate who is unable to hold office. The Constitution does not allow someone who is under 35 years old at the time of inauguration to hold office, or well, at any point to hold office as president. Therefore, they cannot hold the office as president or vice president. Therefore, they similarly cannot be on the ballot for either of those positions. Because even if you were to say, well, they're vice president, so they don't have to hold the office yet, they'll turn 35 soon. In theory, the president could die on Inauguration Day, and then the vice president would take over, and then they would be holding office unconstitutionally. So that's why they can remove a 34-year-old, is there is no mechanism by which a 34-year-old can hold the office of president. The Constitution is explicit and clear that they must be 35. So removing them from the ballot is proper no matter where they are. That is why that is allowed. But this is different. This is requiring some sort of finding of participation in an insurrection, and then also similarly applying disqualification, which isn't listed anywhere in how this would be done. Disqualifying a 34-year-old is easy. The Constitution disqualifies them. Now, you can maybe say that the Constitution by Article 3 or Section 3 of the 14th Amendment, it disqualifies someone in this capacity, but none of those findings have actually been made. Let me just put it this way also. Similarly, in case people aren't following this, what happened on January 6th is not an insurrection just because people didn't like it. That's not what makes it an insurrection. And realistically, I'm not sure there's any finding applicable to anyone outside of maybe a specific context of a specific participant with their specific intent that sufficiently satisfies the Insurrection Act, that we can call this thing generally an insurrection. Now, maybe there was an insurrecting group that participated in January 6th. That is possible. But can we say everyone at January 6th is an insurrectionist automatically? How can you? Well, they participated or supported insurrection. You can't say that either. A lot of those people just were there to have their voices heard. And that some people call them insurrectionists doesn't make it so. You have to have some finding to get there. And that finding would be a criminal conviction where their due process rights are respected. Trump's due process rights have not been respected under the Fifth Amendment here. It's got a huge issue with them finding insurrection. Insurrection's a crime. You can't just decide someone insurrected as an official act of the government, decide this insurrection applies. Again, this just trumps all of the due process rights that would be available to Donald Trump. I'm going to pop over to the bathroom real quick. I will be right back, and we'll get right back into this. Give me just a second, guys.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited. What you have for us when your being is through. When you have a small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. washing your hands and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, just drink some when the stream is over. When you have small bladder and no sphincter control, freedom of liquor doesn't mean freedom from soaking your drawers. Soaking your drawers.
All right. Sorry about that, guys. Got to get back to it. All right. This is driving me fucking nuts. All right. Here we go. Oh, shit. Mr. Rogers says, Merry Christmas to you and your family. Thanks for all the great whiskey suggestions, laughs, and hours of content. Cheers. Drink whiskey, tell jokes, and talk shit. Cheers to that, brother. We can and will do it. Mm. Okay, here we go. Back to this. Section 3. Let's check out the court's analysis on this one. The end of the Civil War brought what one author has termed a second founding of the United States of America. See Eric Foner, the second founding, how the Civil War and Reconstruction remade the Constitution. Reconstruction ushered in the 14th Amendment, which includes Section 3. Yeah, this is great. The 2019 text is going to tell us all about it. A provision addressing what to do with those individuals who held positions of political power before the war, fought on the side of the Confederacy, and then sought to return to these positions. Oh, yeah, that's what the 14th is about? That's cool. Very cool. Section 3 provides, we read it just a second ago, in interpreting, I gotta make this bigger. There we go. In interpreting a constitutional provision, our goal is to prevent the evasion of the provision's legitimate operation to effectuate the drafter's intent. Oh, that's nice. Pretty fucking clear. To do so, we begin with Section 3's plain language, giving its terms their ordinary and popular meanings. To discern such meanings, we may consult dictionary definitions. If the language is clear and unambiguous, then we enforce it as written, and we need not turn to other tools of construction. Well, it's pretty unambiguous, I think. However, if the provision's language is reasonably susceptible of multiple interpretations, then it is ambiguous, and we may consider the textual, structural, and historical evidence put forward by the parties. And we will construe the provision in light of the objective sought to be achieved and the mischief to be avoided. These principles of constitutional interpretation apply to all sections of this opinion in which we address the meaning of any constitutional provision. Okay, so they're going to go with any clear and unambiguous meaning. That's going to stick. But if there's not, then they get to interpret it. But to me, this is very clear. So I'm not sure. The state court has the authority to adjudicate a challenge to presidential candidate qualifications under the election code. All right, perfect. Let's see how they get to this. Shansel says the only sensible part of this entire document is Sammer's dissent. Highly recommended skipping ahead once you get sick of reading repetitive dribble. I might do it tomorrow. I'm not going to do the dissent tonight. Sorry. I'm not going to do the dissent tonight. We may do it tomorrow. I'm going to hit this one, and then we got to get to the next topic pretty soon, which is my own shit, which is always fun. Yeah, Dirk Diggler. Nick is off as fuck tonight more than usual. Yeah, I am distracted right now by... I have an ongoing issue, which is annoying, and I tried to get it dealt with before the show. It's not dealt with, and so it's like it keeps cropping up. And it keeps fucking distracting me. I'm trying, should be over very soon, but it's anyway, I'm sorry about that. We'll get into this a little bit more in a second. All right. The elector's claim is grounded in sections 1.4.1204 and 1.1.113 of the election code. They argue that it would be a breach of duty or other wrongful act under the election code for the secretary to place President Trump on the presidential primary ballot because he is not a qualified candidate based on Section 3's disqualification. The electors therefore seek an order pursuant to Section 1.113, directing the secretary not to list President Trump on the presidential primary ballot for the election to be held on March 5th. But there isn't a disqualification, and that's the critical part of this. This is what bothers me. How are they making the determination that he's disqualified? President Trump and CRSCCs contend that Colorado courts lack jurisdiction over the elector's claim that the electors cannot state a proper Section 11113 claim, in part because the elector's claim is a constitutional claim that cannot be raised in Section 11113. Action under this court's decisions in Frazier v. Williams and Kuhn versus Williams. CRSCC also argues that the secretary lacks authority to interfere with the political party's decision-making process or to interfere with the party's First Amendment right of association to select its own candidates. Lastly, President Trump argues that the expedited procedures under Section 1113 are insufficient to evaluate the elector's claims. Before considering each of these arguments in turn, we first explain the standard of review for statutory interpretation, then provide an overview of the election code provisions at issue. Turning to interveners' contentions, we first conclude that the district court had jurisdiction to adjudicate the elector's claim under Section 11113, but recognizing that the ability to exercise jurisdiction here does not mean the electors can state a proper claim under there. We explore whether states have the constitutional power to assess presidential qualifications. We conclude that they do, provided their legislatures have established such authority by statute. Analyzing the relevant provisions of the election code, we then conclude that the General Assembly has given Colorado courts the authority to assess presidential qualifications and, therefore, that the electors have stated a proper claim under these sections. We next address interveners' related arguments. Okay, so they conclude that somehow Colorado law gives Colorado courts the authority to do this federal determination, which is just crazy. Which is just crazy. I'm not going to go through the standard of review or the presidential primaries under the election code. Certainly, they have the authority to, the Secretary of State has to, by law, have the authority to put someone on the ballot. That's every state has that. So therefore, the Secretary of State has a duty to do so lawfully, only by the, the authority granted to it by the statutory law. That makes perfect sense. That is fine. And as such, yes, a Secretary of State can assert the qualifications of someone to be listed as president. That is well within their purview. The problem is in making a determination of disqualification at this court level over a president when there is no underlying support. And I've been going through this forever. Hold on. Give me one more second, guys. I'll be right back. Okay, sorry about that. I have put my distraction aside permanently. I just needed to take a minute and get rid of it and get that away. Otherwise, I'm going to be darting my eyes over this fucking thing all night long, and I can't do that for the show. I'm sorry for having that be a distraction for me during this thing. Sometimes shit comes up and you're like trying to deal with it, and I deal with a lot of people who have a lot of issues for all sorts of reasons, and that's one that just I had to address some stuff, and now it's gone. So my apologies for that. It was just an annoying fucking thing, and it doesn't need to be dealt with tonight, but it's my fault that I was trying to deal with it, and so I had to put that aside for my own benefit here so we can do the show. All right, back to this. We have, again, this whole way that the court is getting to their ability to find out if a president is Let me make a distinction here. The Secretary of State's job is to put a qualified candidate on the ballot, or to not put a disqualified candidate on the ballot. What we have here is an overstep. We have an overstep going on where they are not just determining whether someone is qualified or not. They are making the qualification determination, and they're doing so exceeding their authority. That is the problem here, and that's the distinction. It's really easy for the Colorado Supreme Court to say, well, obviously the Secretary of State has the authority to put someone on the ballot or take someone off. But it's not discretionary authority. The Secretary of State doesn't get to make the determination that someone doesn't belong on there. They're either qualified or they're disqualified, and they're qualified or disqualified by clear and unambiguous rules or rulings. There's a problem when you... Let me take it a step farther. The Secretary of State is the representative of the executive of the state, the executive authority executing laws of the state. The Secretary of State represents that. So what we must logically infer is that the authority granted to the Secretary of State to make or to place someone on the ballot who is qualified and to not place someone on the ballot who is disqualified is derived from the state's authority itself. The state does not have the authority to make the determination that a president is disqualified from the ballot. That's the difference. That's the problem that we're facing here, is that the authority to determine placing on the ballot hinges entirely on qualification versus disqualification. But that determination is not made by the state. The state does not have sufficient authority to do so, or rather should not, because it violates the principles of federalism, the separation of powers, and all concepts of reasonable governance. Because if, let's say, California removes you, even though we know California is going to go to a Democrat, let's say California disqualifies a Democrat candidate, anyone. Does that candidate have a prayer of holding office? Let's say Texas disqualifies, or Florida disqualifies a Republican candidate through an individual act for whatever reason. Do they have a prayer of winning the election? No. No other voter in any other state will be enfranchised by their vote for that candidate if they remain on the ballots of every other state. You've now completely disrupted the election process. There's effectively no way those candidates could win. I go specifically to Republican and Democrats because those are Republican and Democrat strongholds as they were talked about. But realistically, they don't have to be Republican or Democrat candidates. Losing 55 electoral votes out the gate as a matter of law is fatal. Imagine where we are. Imagine what Colorado is effectively doing here. Any president with any act in their history that could could conceivably construed as insurrection or giving aid and comfort to insurrection could remove a president from their ability to access electoral votes. Any state. How many presidential candidates had some role in January 6th? We've heard about congressmen, very prominent congressmen who quote unquote received phone calls or text messages or whatever during this. Ted Cruz, Tom Cotton, These guys are potential presidential candidates. Could they ever be president? Ever? Like Kevin McCarthy for a while. I mean, he's faded now, faded like a flower by Roxette. Like he's out, but these people are implicated in all of this shit. By somebody. Participation, aid, and comfort. So what about a lawyer who represents the January 6th defendant? A lawyer who represents a January 6th defendant, can they run? Are they disqualified under the 14th Amendment? Not supposed to be, but are they? What about someone who interviewed them? What if they paid for the interview? What about a book publisher? What about a ghostwriter? What about a personal representative or personal assistant or scheduler or a chauffeur? What about these people? Are they qualified to ever run? Could they be disqualified by a state for any whim? This is a dangerous precedent Colorado is setting. It's fucking crazy to think what they're doing here. We're almost done with this issue. I'm going to skip most of this stuff. Here we go. States have the authority to assess presidential candidates' qualifications. So here's their justification for the state's inherent power to do so. Common sense, as well as constitutional law, compels the conclusion that government must play an active role in structuring elections. The Constitution delegates to states the authority to prescribe the times, places, and manner of holding congressional elections, and states retain the power to regulate their own elections. Yeah, this is not going to go the way. This argument is not great. You can already see it from the start. States exercise these powers through comprehensive and sometimes complex election codes, regulating the registration, qualification of voters, the selection and eligibility of candidates, and the voting process itself. These powers are uncontroversial and well explored in U.S. Supreme Court case law. Yeah, but that is not. No. This is way different than disqualifying a president from access to just your state's electoral votes by a finding in civil court without a conviction. That's way different. But does the U.S. Constitution authorize states to assess the constitutional qualifications of presidential candidates? We conclude that it does. Oh, do you? Let's see. Under Article 2, Section 1, each state is authorized to appoint presidential electors in such manner as the legislature thereof may direct. Wait a minute. Yeah, and the legislatures thereof have directed that a popular vote is the way to do this. So long as a state's exercise of its appointment power does not run afoul of another constitutional constraint, that power is plenary. But they did this already, and this is not being done by the legislature. This is being done by the fucking courts. But voters no longer choose between slates of electors on election day. Yes, they do. Oh, yes, they do. What the fuck are you talking about? Instead, they vote for presidential candidates who serve as proxies for their pledged electors. Yeah, but they're still voting for slates of electors. Accordingly, states, no one was voting for electors. They were voting for the candidate. That was always the case. Accordingly, states exercise their plenary appointment power not only to regulate the electors themselves, but also to regulate candidate access to presidential ballots. The fact that these states, that you can vote for Donald Trump, for example, and that their electors could choose someone else shows you that the proxy election still is electing the electors. It's not electing the president. What are we talking about here? They're completely butchering how election law and process actually works. Accordingly, states exercise their plenary means unquestionable appointment power, not only to regulate the electors themselves, but also to regulate candidate access to presidential ballots. The legislature, not states, the state legislature, absent a separate constitutional constraint, then states may exercise their plenary appointment power to limit presidential ballot access to those candidates who are constitutionally qualified to hold the office of the president. You need the legislature to do so. Nothing in the U.S. Constitution expressly precludes states from limiting access to the presidential ballot to such candidates. No party in this case has challenged the secretary's authority to require a presidential primary candidate to confirm on the required statement of intent form that he or she meets the Article 2 requirements of age, residency, and citizenship, further attest that he or she meets all qualifications for the office prescribed by law. Okay. Moreover, several courts have expressly upheld the state's ability to exclude constitutionally ineligible candidates from their presidential ballots. See it upholding California's refusal to place a 27-year-old candidate on the presidential ballot. 27-year-old candidate is unambiguously disqualified from holding office, affirming the secretary's decision to exclude a naturalized citizen from the presidential ballot. Natural born citizen, just categorically and unambiguously disqualified from office. Get something close. Affirming Illinois' exclusion of a 31-year-old candidate. Oh, not even close. These are unambiguous. There is no finding that is necessary. None of this required a conviction. What's their age again? Later on the drive home, I called your mom from a payphone. I said I was President Trump and your husband's and Joe Biden's in jail. The state looks down on side of me, right? Like, we know what's going to happen here. These aren't questions that need to be asked. They're answered by empirically obvious, unambiguous facts. What is the age of the person? What is the age requirement? A finding of insurrection or providing material aid and comfort is not a minor thing. It's not obvious and open. No one's even charged Trump with insurrection. All right. For just a minute, we're going to read the rest of the super chats here on YouTube. We're going to pop over to Rumble and get over there and continue the show over there. Doc Salty. By the way, if you want to pop over to Rumble with us, the link is in the description. It's also in the pin chat from C. Goody. Make sure to join us over there, and we will continue the show. Doc Salty 96. Hey, Ragus, just wanted to see if I can get a happy birthday from me. Turned 27 today. Hope all is well with you and yours. Doc Salty, of course you can. What you cannot do is run for president. Can't do it. Can't do it at all. But cheers to you. Happy birthday, brother. 27 years old. Enjoy it. Grow older. Get wiser. Get stronger, faster. Have better access to the internet and have people respect you just a little bit more each day for reasons you can never describe. Cheers to you. Have a good time, brother. Lansfin 85, the unarmed insurrection where Trump told everyone to go home. Yeah, they just leave out those parts of the speech. They leave out all the mitigating shit. They leave out the peacefully hear our voices, let your voices be heard, all of that stuff. Rael, please recite the Pledge of Allegiance. Serious. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, liberty and justice for all. But if you go pre-1962, just take out under God if you want, I guess. Is that what you wanted? Like, I don't know. Rail says, but the Dems Repubs keep saying we're a democracy. Oh, because into the republic for which it stands. Yes, we are a constitutional republic, although that has been taken down, diluted, we'll say, quite a bit. Three says, so what we were told, and we've told our kids that uniquely, just by being born in America, anyone can grow up to be president is basically bullshit. How demoralizing and way to go on inspiring good young people to get involved. Well, they still can. The idea is that there is some level of activity you can do that will preclude you from being president, but it's a really narrow and limited set of things. Actually, yeah, it only really has to do with citizen issues, renouncing your citizenship, having dual citizenship, dual loyalties, split loyalties to other countries. That's it. I would contend that Article or Section 3 of the 14th Amendment does not cover a president, does not preclude you from being president. Not everybody agrees with that. Clearly, Colorado Supreme Court doesn't, but other courts across the nation do agree with that, and I think that's a proper outcome. I think the Supreme Court should deal with this very quickly. Bass player 2011 IFY Says this ruling has been stayed until January 4th, and if it goes to SCOTUS, it will be stayed until SCOTUS makes a decision. Page 8 and 9. This isn't worth the paper it was written on. SCOTUS may not take it up. I think they will, but there's always a possibility that they won't. Andre Tukulescu says hello from Canada. By the way, it is it's worth a lot. The paper is worth a lot, though. You're saying it's not worth the paper it's printed on. I hear what you're saying, but the paper's worth a lot because other courts will look to this for guidance, support, and determination. Other states will be emboldened by the rulings. All of this stuff is really a giant mess. They have just ham-fisted in a ruling that disrupts everything about a stable representative republic, because as a state now, they have disenfranchised other states. Andre Tukulescu, hello from Canada. Y'all are fucked almost as bad as us. And before you talk back, remember, we burned your capital in the War of 1812. Yeah, but you apologize for it, you fucking Canadians. I hope Trudeau wears blackface and robs all your liquor stores. Rail, when Trump goes full legal presidential retaliation, I hope each Dem cell plays their own voice clips on repeat 24/7 of "No one is above the law." That'd be good. Let's see. Tyranidas says, find page 104. I think when they mentioned 1807 law about traitors, in the law they cite would literally label millions as traitors. We'll check that in a minute just for fun. Kate C, aka Snake Plush Kitten. Nick, since the court is denying voters a chance to vote, are they in violation of the Federal Voters' Rights Act of 1965? Well, they're not denying a chance to vote. They're denying a chance to vote for a specific candidate who they are claiming is disqualified under the Constitution. So no. Toddzilla, if the SCOTUS upholds this, doesn't this mean every state can do the same? Yes. Was Colorado court trying Trump for insurrection? They made findings of fact and conclusions of law in accordance with a complementary civil issue in a civil court. They did not find him guilty by a jury. The court, which means a judge, made findings of fact and conclusions of law that Donald Trump engaged in insurrection by clear and convincing evidence. Yeah. He was not on trial for insurrection. No. Again, it was a civil case. So he was not found guilty beyond any reasonable doubt, as a criminal case would require. His Fourth, Fifth, and Sixth Amendment rights were not necessarily observed. But hey, who cares, right? Matt, how do I ask you a curious and personal legal question? You can email it to me and I may get to it. This time of year is really tough for me. I'm not up on everything that's going on. Brandon Keller, does Section 5 of the 14th mean anything? Has Congress passed any legislation to enforce the provisions in the 14th? Yes, tons of them, but just not this one. Also, does that implicitly bar states from enforcing it? Maybe. So what he's asking about is Section 5 here, which is this is actually kind of a boilerplate. It's kind of a boilerplate section. It just says Congress shall have the power to enforce by appropriate legislation the provisions of this article. But all of the provisions of the article are here. The Civil Rights Act of 1964 is enforced by an act of Congress and has to do with, the Civil Rights Act of 1964. Look at this. No state shall make or enforce any law which shall abridge the privileges or immunity of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So equal protection and substantive due process are the roots, hashtag roots like Kunta Kinte, of the Civil Rights Act and other civil rights style legislation for anti-discriminatory shit, right? Title VII, Title IX, all of that stuff. That comes. Congress has made laws pursuant to these ends. They have not made laws pursuant to finding a president disqualified, because Congress may not actually be able to do that. That's another weird thing. I hate to belabor this, But let's go back to this. Where does it give anyone the power to determine a president is disqualified or anyone is disqualified? Where does it give them the power to make the determination? It's not there. The reason that it's not there is because the insurrection they're responding to was so open and notorious that it would be impossible to not know. Brack says you can tell that Trump has not been found guilty of insurrection because he has had no trial or sentence. I need to, yes, but I need to be clear. The 14th Amendment does not require a trial and a conviction because the 14th Amendment was written as a specific response to the most notorious type of insurrection you could get. The South insurrected in so much as they sent letters and said, fuck y'all, we out of here, we got our own army, and if you want to fucking make us stay, you better come fucking fight us and we will fucking shoot you, right? It's not hard to see how this went. The South said, we got guns, we got bitches, we got Negroes, and we have money. We're going on. We can go our own way, buy our own slaves, right? Like they had it. They knew exactly what we're gonna walk away. We're gone. Peace. Insurrected insofar as, why was it an insurrection though? Because you don't have the authority to leave the union once you join. You do not have it. I know people think like, well, any state could just, well, I think we just bow out. No. To leave the union, you need a vote of 2/3 of the state, or 2/3 or 3/4 of the state, something like that. You have to have permission from the rest of the union because those other states are relying on your resources, your people, your tax, like all of that feeds into the union itself. So this is Texas v. White, post-Civil War case where they basically said the southern states didn't have the authority to leave the union. People can debate it all day. That's what the Supreme Court found. Yes, the victors made the determination. But realistically, that's why it was an insurrection. That's why the language is used. They said that the South rebelled against the state, the nation state, in an insurrection. Not because they were trying to take it over, but because they were trying to fuck off from it. But fucking off from it wasn't allowed because the other states needed the South. They needed their people. They needed their resources. They needed their money. They needed their taxes. They needed their politicians. They needed all of those things to persist as a major state. And by taking that away, they would be effectively taking some property interests that northern states had in the concept of southern states and in the income that they produce and the benefits they produce to the north. That's the whole purpose of the union. All right. I feel like I need to rant, not tonight. I feel like there needs to be like a 3-hour video on just what matters about this, the Civil War in terms of political power, in terms of states' rights, in terms of everything that was at stake, in terms of why it's insurrection, in terms of what was being slighted and taken by the leaving of the South. Like, I feel like no one actually understands this stuff because it's never addressed in the way of what is the power dynamic here? What is the struggle? What is the desire? It just goes herpa-derpa slavery all the time. And yes, slavery is a critical issue of the Civil War, but it's a critical issue in context of broken promises that are in the Constitution, routinely broken by the North, the South feeling slighted, and the South saying, hey, we don't fucking need this. We signed a contract and they're not honoring it. What do we fucking do here? Oh, we just go leave. We're going to fuck off and do our own thing. And then the North going, we need them. We want their slave Negro labor, even though we made it illegal because we want cheap shirts. Same reason we buy iPhones from China when China's a monster. But they said that we want cheap shirts. We want cheap cotton. Walking in high cotton. Those Negroes are not forgotten. Those lynching fields are never far away. Like, this is what they wanted. The North wanted to rely on the South's use of slave labor. There was an eventual plan to phase it out, maybe, so long as that slave labor kept benefiting the North, though. They were really fucking happy, and they hated black people, too. It's not like the North were these benevolent whites who are like, oh, actually, we're the erudite whites, even though we're the erudite whites who like the blacks. No, they were shitty towards them just as much. They just didn't own them. Just everything else the same. But hey, I feel like that needs to be addressed because it's fucking crazy how bastardized these issues are and how like distilled down into the most basic and not important parts the Civil War is. It's like if the Civil War was literally just over, can you own slaves? The South would have lost a lot sooner. It's really hard to take up arms and fight in a grueling, bloody, nasty, ongoing war just over can I own black people? Because there were ways for decades and decades to own, maybe a century, to own black people after the Civil War just without owning them. You didn't have to treat them well. You didn't have to. There wasn't a Civil Rights Act. 1964. Civil War ends in 1865, a fucking century before the law starts to require you to treat them the same. Starts. And you just look to the North. They didn't treat blacks well. They didn't do great in the North. It's not like the United States is a great place for blacks, except for the South, though. Like that was never a thing. So there's no reason to determine, like, anyway, I'm getting way off on a fucking rant and I hate it because there's an underlying rant about this, but it's like, everybody's like, oh, the Civil War is about slavery. It's like, well, it's a component. They're like, it's a main component. It's like, no, it's the catalyst. It's the representative thing. It represents the broken promises of the North that are written in the Constitution. They're gross. They're abhorrent. We don't like them, but they were written in there. And the North wasn't good. They weren't good actors. They didn't have a public pool that taught black people to swim. It's not like the North was great. They just weren't. They didn't own people. That's all. But the North benefited from that ownership and they loved it. It's so weird that we just ignore all of that shit. Anyway, where my ultimate point was, this is one of the most open and notorious insurrections that's possible. Everybody has known. The reason that Article 3 is here and enforceable in the context of the Civil War is because there was no question. But there is no subsequent enforceability. You would suspect that you would need a similarly catastrophic insurrection as the Civil War to again engage the 14th Amendment in an obvious, open, and notorious way. Otherwise, you got to have a fucking criminal conviction. I also think that even with a criminal conviction, a president cannot be disqualified. Here we go. Tyrannidis says, before moving to your stuff, please read the definition of the treason the Colorado court uses on page 104. It's bonkers. I will. Tamery says, what about ideas of GOP caucus like low possible? I don't know what you mean by that. Sorry. Nara Dak says, the 4 members of the Colorado Supreme Court are undermining our democracy. It's time to bring out the tar and feathers, Colorado, like yesterday. Tank Imperator says, Merry Christmas, my friend. Hey, Merry Christmas to you. Also, Canada has never apologized for war crimes. We actually invented a few during Christmas, World War I. They would throw over tins of beef and chocolate. When the Germans cried for more, they threw hand grenades. Holy shit. Lawson says, Canada only apologized for 1812 because you were so butthurt. Trudeau wears blackface to a party. Are you offended? You disavow it like Ricada docs. No, I'm not offended. I said he'd rob all your liquor stores. He's going to bring good stuff to the party. Leave me alone. Nerdak, I've never supported violence against any elected or appointed government officials. If this don't have, get your house in order, Colorado. Jip V, you didn't read the textbook by Daniel Miller I gave you at Matsuri Texit book, did you? You need to get him on cross-exam. I have not read it. I hate to say he's just not correct, but I have not read it. Ian So Forth, thank you for the very nice super chat. And we'll go to page 104 real quick. This is it. Here we go. And then right after this, we're going to pop over to Rumble. So the furtherance of the common unlawful purpose or do any. So this is let's do this, I guess, this way. Starting at page 103, Attorney General Stanberry's opinions on the meaning of engage, which he issued at the time the 14th Amendment was being debated, are in accord with these historical and modern definitions. Okay. Attorney General Stanberry opined that a person may engage in insurrection or rebellion without having actually levied war or taken arms. Thus, in Attorney General Stanberry's view, that's the Attorney General's view, when individuals acting in their official capacities act in the furtherance of the common unlawful purpose or do any overt act for the purpose of promoting the rebellion, they have engaged in insurrection or rebellion for Section 3 disqualification purposes. Cool, I guess. Citing the Attorney General at 204, defining engaging in rebellion to require an overt or voluntary act done with the intent of aiding or furthering the common unlawful purpose. Accordingly, disloyal sentiments, opinions, or sympathies would not disqualify, but when a person has by speech or by writing incited others to engage in rebellion, he must come under the disqualification. According to, again, General Stansbury in 1865, turning to case law concerning the meaning of engagement for purposes of Section 3, although we found little precedent directly on point, cases concerning treason that had been decided by the time the 14th Amendment was ratified provide some insight into how the drafters of the 14th Amendment would have understood the term engagement. For example, in Ex parte Bolleman, Chief Justice Marshall explained that if a body of men be actually assembled for the purpose of effecting by force a treasonable purpose, all those who perform any part, however minute or however remote from the scene of action, and who are actually leagued in the general conspiracy, are to be considered as traitors. In other words, an individual need not directly participate in the overt act of levying war or insurrection for the law to hold him accountable as if he had. It is not necessary to prove that the individual accused was a direct personal actor in the violence. If he was present, directing, aiding, abetting, counseling, or countenancing it, he is in law guilty of the forcible act. Nor is even his personal presence indispensable. Though he be absent at the time of its actual perpetration, yet if he directed the act, devised or knowingly furnished the means for carrying it into effect, instigating others to perform it, he shares their guilt. In treason, there are no accessories. Now, this is interesting because it still requires the knowingly furnished the means, devised or knowingly furnished. You have to have intent here. You have to have intent. I don't know what you wanted me to find that you found objectionable there. I didn't see where it was crazy, but it's I don't know. It still requires an act actually against the government, which January 6th is not. Icon of Sin says, love you lots, Nick. Miss you, miss chat, miss game nights. Bombshman Spirit. Also, Canadians like to pretend they played a big part in 1812. They didn't. With that, guys, we're going to go over to Rumble exclusively. Thanks for hanging and bearing with me on this very weird night. We're going to get over to Rumble, and we are going to finish up the show over there. We'll see you in a bit. Hit the link in the pinned post or in the description, and we will catch you next time. Have a good night. Peace, guys. Peace.